into their argument before they're interrupted. What we're going to hear is part of two arguments. The case was argued twice, a year apart, 1971 and 72, probably because the first argument there were only 7 justices on the bench. Hugo Black and John Harlan had died shortly before these arguments, and afterwards I think the court decided that it would be better to wait until their replacements were on the court before deciding it. The lawyers we're going to hear, Sarah Weddington, who is representing Jane Roe, was at the time only 25 years old. This was her very first argument, in fact, her very first case and client. However, she had spent about a year preparing for this argument. On the other side, representing the state of Texas, defending its law against abortion, is an assistant attorney general named Jay Floyd. He had not, I think, and he has admitted this himself, spent as much time in preparation. I think you get a sense listening to this of the difference in approach to oral argument.
And I should point out to the audience, as you listen, you will hear a voice kind of offering instructions as to what's happening next. That is the voice of Professor Irons giving us a clue as to who's speaking. Let's listen to about 5 minutes of this first oral argument of Roe versus Wade, and then we'll come back with Professor Irons.
We'll hear arguments in number 18, Roe against Wade.
This is Peter Irons. We're in the chamber of the United States Supreme Court in Washington, D.C. It's December 13th, 1971. Chief Justice Warren Burger has called a case that raises an unsettled and unsettling issue in American society, abortion. Only 7 justices sit behind the bench. 2 longtime justices, Hugo Black and John Harlan, died recently and have not yet been replaced. Lawyers, reporters, spectators pack the courtroom. Sarah Weddington argues for Jane Roe.
Mrs. Weddington, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the court. Certainly Jane Roe brought her suit as soon as she knew she was pregnant, as soon as she had sought an abortion and been denied. She came to federal court. She came on behalf of a class of women, and I don't think there's any question but that women in Texas continue to desire abortions and to seek them out outside our state.
In 1970, an unmarried pregnant woman, using the pseudonym Jane Roe, sued Henry Wade, the Dallas, Texas district attorney. 2 young lawyers, Sarah Weddington and Linda Coffey, asked the federal court to declare unconstitutional the Texas criminal law prohibiting any abortion not intended to save the mother's life. They also sought to bar the district attorney from enforcing the law. The federal judges ruled that the Texas law violated the 9th Amendment to the U.S. Constitution, which reserves to the people those rights not granted to the states. But the judges declined to block enforcement of the law. Both sides appealed to the Supreme Court. Sarah Weddington is making her first argument to the court.
In Texas, the woman is the victim. The state cannot deny the effect that this law has on the women of Texas. Certainly there are problems regarding even the use of contraception. Abortion now for a woman is safer than childbirth. In the absence of abortion or legal, medically safe abortions, women often result to the illegal abortions, which certainly carry risks of death, all the side effects such as severe infection, permanent sterility, all the complications that result. And in fact, if the woman is unable to get either a legal abortion or an illegal abortion in our state, she can do a self-abortion, which is certainly, perhaps by far the most dangerous, and that is no crime.
Weddington said that Texas allowed no abortions if pregnancy did not endanger a woman's life.
If the pregnancy would result in the birth of a deformed or defective child, she has no relief. Regardless of the circumstances of conception, whether it was because of rape, incest, whether she is extremely immature, she has no relief.
She moved on to the law's impact on women.
I think it's without question that pregnancy to a woman can completely disrupt her life. It disrupts her body, it disrupts her education, it disrupts her employment, and it often disrupts her entire family life. And we feel that because of the impact on the woman, this certainly, in as far as there are any rights which are fundamental, is a matter which is of such fundamental and basic concern to the woman involved that she should be allowed to make the choice as to whether to continue or to terminate her pregnancy.
Justice Potter Stewart shifted the discussion to constitutional issues.
Mr. Weddington, so far on the merits, you've
about the important impact of this law, and made a very eloquent policy argument against it. I trust you are going to get to what provisions of the Constitution you rely on, because, of course, we'd like to. Sometimes we cannot here be involved simply with matters of policy, as you know.
Your Honor, in the lower court, as I'm sure you're aware, the court held that the right to determine whether or not to continue a pregnancy rested upon the Ninth Amendment, which, of course, reserves those rights not specifically enumerated to the government, to the people. I do feel that that the Ninth Amendment is an appropriate place for the freedom to rest. I think the 14th Amendment is equally an appropriate place under the rights of persons to life, liberty, and the pursuit of happiness. I think in as far as liberty is meaningful, that liberty to these women would mean liberty from being forced to continue the unwanted pregnancy.
You're relying in this branch of your argument simply on the Due Process Clause of the 14th Amendment?
We had originally brought the suit alleging both the Due Process Clause, the Equal Protection Clause, the Ninth Amendment, and a variety of others.
And anything else that might have been.
Yeah, right. Yeah.
Sarah Weddington responded with this concise statement.
One of the purposes of the Constitution was to guarantee to the individual the right to determine the course of their own lives.
Justice Byron White pressed the troubling question of how far the right to an abortion would go.
Well, Professor Irons, one thing I learned was where you got the title of your book, May It Please the Court. Does everybody use that phrase?
Virtually every lawyer begins by saying, Mr. Chief Justice, and may it please the court. It goes back to antiquity. I don't know when it started, but it's become a tradition.
Toward the end of that clip of about 5 minutes, there was comment about whether or not, a discussion whether or on what basis the right to abortion was based. And Mrs. Weddington seemed to not make a particular choice. Didn't that issue resonate recently in the Judge Ginsburg hearings?
Well, I think what it raises, and it's very interesting going back 20 years, that Sarah Weddington, in her first argument, was sort of rummaging through the Constitution. I don't think she had really thought through the issue, because the district court had said, well, the Ninth Amendment protects the right to an abortion. But the Supreme Court has always been very wary of the Ninth Amendment. It's sort of like a Pandora's box. You open it up and you don't know what kind of rights are going to jump out. So that's why I think she was, Justice Stewart asked, and any other rights that you could think of, and people laughed at her answer. But I think that now there's more of a recognition that perhaps there are a number of provisions in the Constitution that can be put together to create this right of privacy that we still argue about.
Forgetting the issues for the moment, in terms of these tapes, what do you think people are going to be most impressed by or surprised by as they listen to these tapes of the Supreme Court in action?
Well, I think one thing they'll be surprised by is that the arguments very rarely deal with highly abstract issues of law. The justices really want to know what's going on. Sarah Weddington began her argument by talking about what's the impact of this decision on women. And I think that very often we tend to forget that the law comes out of specific situations and cases, that in fact we develop our legal principles by looking at what happens to people when they're confronted in a situation where they have to make some choice, and the choices are not easy.
We're going to continue. We're going to pick up where we left off, listen to another 5 minutes of this, during which time we hear the other side. Do you have anything else to say about the next segment, Professor?
Well, I think what people will hear for themselves is what happens when a lawyer gets sort of caught and doesn't have an easy time framing his argument.
And that would be whom?
That would be the Assistant Attorney General from Texas.
All right, let's listen to the next portion of the oral argument of Roe versus Wade.
Will that take you right up to the time of birth?
It is our position that the freedom involved is that of a woman to determine whether or not to continue a pregnancy. Obviously, I have a much more difficult time saying that the state has no interest in late pregnancy.
Why is that?
I think it's more the emotional response to a late pregnancy rather than it is any constitutional.
By whom?
I guess by persons considering the issue outside the legal context. The Constitution, as I see it, gives protections to people after birth.
Sarah Weddington sat down at the council table with Linda Coffey. Texas Assistant Attorney General Jay Floyd began with an attempt at humor.
Mr. Chief Justice, may it please the court. It's an old joke, but when a man argues against two beautiful ladies like this, they're going to have the last word.
No one laughed. Chief Justice Berger looked annoyed. After an embarrassed silence, Jay Floyd argued that the case was moot because Jane Roe was no longer pregnant. One of the justices pushed Floyd.
What procedure would you suggest for any pregnant female in the state of Texas ever to get any judicial consideration of this constitutional claim? Your Honor, let me answer your question with a statement, if I may. I do not believe it can be done. There are situations in which, of course, as the court knows, no remedy is provided. Now, I think she makes her choice prior to the time she becomes pregnant. That is the time of the choice. It's like more or less, the first 3 or 4 years of our life, we don't remember anything. But once a child is born, a woman no longer has a choice, and I think pregnancy may terminate that choice as well. Maybe she makes her choice when she decides to live in Texas.
Floyd's claim that no woman could challenge the Texas law prompted more questions.
In a constitutional case of this kind, it becomes quite vital sometimes to rather precisely identify what the asserted interest of the state is. The protection of the mother at one time may still be the primary, but the policy considerations, Mr. Justice, would seem to me to be for the state legislature to make a decision. Certainly that's true. Policy questions are for legislative and executive bodies, both in the state and federal government. But we have here a constitutional question, and in deciding it, assessing it, it's important to know what the asserted interest of the state is in the enactment of this legislation. I am, and this is just from I speak personally, may I may. I would think that even when this statute was first passed, there was some concern for the unborn fetus. When was it enacted? I believe it was 1859 was the original statute. This, I believe, was around 1900, 1907.
Justice Thurgood Marshall and Jay Floyd debated the question of when life begins.
We say there is life from the moment of impregnation.
And do you have any scientific data to support that?
Well, we begin, Mr. Justice, in our brief with the development of the human embryo, carrying it through to the development of the fetus from about 7 to 9 days after conception.
Well, what about 6 days?
We don't know.
But this statute goes all the way back to 1 hour.
I don't, Mr. Justice, there are unanswerable questions in this field. I
appreciate it.
This is an artless statement on my part.
I withdraw the question.
Thank you. Or when does the soul come into the unborn? If a person believes in a soul, I don't know.
Jay Floyd argued that the justices had nothing to decide.
There is nothing in the United States Constitution concerning birth, contraception, or abortion. We think these matters and matters of policy should be properly addressed by the state legislature.
After oral argument, the justices discuss and vote on cases behind the closed doors of the court's conference room. On rare occasions, the court does not decide a case and schedules further argument. Roe v. Wade was one of these cases. The court does not disclose its reasons. Perhaps the justices felt that such an important and controversial issue as abortion deserved a vote by the full court of 9 justices.
Professor Irons, a couple questions about this. The audio quality, is it such that you can identify, or did you ever have trouble identifying which justice was speaking at any given moment?
Sometimes we did. The transcripts don't identify which justice is speaking, and so you have to develop a sense of what people's voices sound like. Some are very distinctive. Justice Marshall, for example, you can always tell if it's him. But occasionally we would have to guess or just say, a justice asked a question.
For example, we're showing the audience some of the script, and you've got here an indication that simply the court is speaking.
That's right. When we can't identify the justice's voice, we just say the court.
Did you ever not pick a case out of the many thousands that you had to choose from because of the quality of the audio?
Yes, there was one case, in fact, we really wanted. It was a case involving school desegregation and busing remedies, and it was called Charlotte versus Swan. And unfortunately, the lawyer who argued that case for the state of North Carolina had several charts that he was referring to, proportions of students of each race in schools, and he would consistently turn around and walk over and point to the charts, getting away from the microphone. So the audio quality of that was not good enough for this series, and unfortunately we couldn't include it.
So far we've heard about 10 minutes of Roe versus Wade. What's the quality of the participation of the justices in this oral argument as compared with, say, any other? Is there anything distinctive about the level of their participation?
I think in Roe versus Wade there was more questioning from the bench, but it's very hard to predict. Some cases that have very important legal issues, the justices basically just sit there and listen to the argument, and questions are very infrequent. And there are other cases where you wouldn't think it was that important, where a particular justice gets on an issue and keeps after the lawyer, question after question. Justice Frankfurter, Felix Frankfurter, once asked 93 questions of a lawyer during an argument.
You offered a few conclusions or observations in your narration. For example, you pointed out that you thought that the Chief Justice was annoyed about that attempt at humor. I wonder how many of those kinds of observations and conclusions you offer in this product that you're putting out.
Well, not very many. I did that, in fact, because people who were at the argument reported from watching the argument that Chief Justice Burger sort of sat back and had a frown on his face. He didn't encourage levity in the court, and I think he considered that joke sort of poor taste.
In a couple of the arguments I've listened to, there are other examples of levity. Can you generalize at all about how loose the court has been since 1955?
Well, I think people will be surprised when they listen to these tapes that, in fact, there's quite a bit of humor. I think most of it is to deflate a tense atmosphere. Sometimes lawyers get very wound up in their argument, or there's a little tension between the bench and the lawyer arguing, and very often a justice will try to lighten the atmosphere by making a humorous remark or interjecting something to just ease the tension.
Well, the first two segments that we heard were of the first argument, and you said that there were two arguments in Roe v. Wade. So we're going to start up with the October 11th, 1972 resumption of the argument. Is there anything you can give us to lead into this one?
Well, for one thing, the case was argued all over from scratch. Sometimes the court will ask for re-argument in a case because there's an issue they hadn't asked about in the first, or they want some clarification. In Roe versus Wade, the lawyers basically were starting all over again. So what you see, or what you hear really, is, unfortunately we can't see it, but what you hear is the attempt of the lawyers to sort of improve on their initial performance, to fill in the gaps and to make things a little more clear when they argue the case again.
Did they, in your opinion?
I think on both sides the arguments were presented much better the second time around, which I would hope would be natural.
All right, let's go to the second round of oral argument in Roe versus Wade.
On October 11th, 1972, when the argument resumed, Lewis Powell and William Rehnquist had joined the court. Sarah Weddington returned for Jane Roe. She had stumbled in her first argument on the constitutional basis for abortion rights. She tried now to repair the damage.
In our original brief, we alleged a number of constitutional grounds. The main one that we are relying on before this court are the 5th, the 9th, and the 14th Amendments. There's a great body of precedent. Certainly we cannot say that there is in the Constitution so stated the right to an abortion, but neither is there stated the right to travel or some of the other very basic rights that this court have held are under the United States Constitution. The court has in the past, for example, held that it is the right of the parents and of the individual to determine whether or not they will send their child to private school, whether or not their children will be taught foreign languages, whether or not they will have offspring, the Skinner case, whether the right to determine for themselves whom they will marry, the Loving case. Griswold, of course, is the primary case, holding that the state could not interfere in the question of whether or not a married couple would use birth control. And since then, this court, of course, has held that the individual has the right to determine whether they are married or single, whether they will use birth control. So there is a great body of cases decided in the past by this court in the areas of marriage, sex, contraception, procreation, childbearing, and education of children, which says that there are certain things that are so much a part of the individual concern that they should be left to the determination of the individual.
Weddington pointed to New York State, which repealed its law against abortion in 1971.
There have been something like 1,600 Texas women who have gone to New York City alone for abortions in the first 9 months of 1971. The overall maternal death rate from legal abortion in New York dropped to 3.7 per 100,000 abortions in the last half of 1971, and that in fact is less than half the death rate associated with live delivery for women. That in fact the maternal mortality rate has decreased by about 2/3 to a record low in New York in 1971.
These facts did not satisfy Justice Byron White. He asked if it were critical to the case that the 14th Amendment did not protect a fetus.
If the state could show that the fetus was a person under the 14th Amendment or under some other amendment or part of the Constitution, then you would have the situation of you would have a state compelling interest, which in some instances can outweigh a fundamental right.
Justice White exploited her concession on this crucial point.
Well, do I get from this, then, that your case depends primarily on the proposition that the fetus has no constitutional rights?
It depends on saying that the woman has a fundamental constitutional right and that the state has not proved any compelling interest for regulation in the area. Even if the court at some point determined the fetus to be entitled to constitutional protection, you would still get back into the weighing of one life against another.
And that's what's involved in this case? Weighing one life against another?
No, Your Honor. I said that would be what would be involved if the facts were different and the state could prove that there was a person for the constitutional right.
Well, if it were established that an unborn fetus is a person within the protection of the 14th Amendment, you would have almost an impossible case here, would you not?
I would have a very difficult case.
Certainly would.
Assistant Attorney General Robert Flowers replaced J. Floyd at the podium. Flowers jumped on Weddington's concession about fetal rights, but encountered a quizzical Justice Harry Blackmun.
We'll get back to that in a second, but I noticed, too, that you've got a man by the name of Griswold speaking in the narration. Who is he?
That's not a man. Actually, that was a case precedent for Roe versus Wade, Griswold versus Connecticut. Griswold was, in fact, a woman, Estelle Griswold, the head of Planned Parenthood in New Haven, Connecticut. But the interesting thing about this segment of the argument is that the second time around, Sarah Weddington had a long list of cases that she cited as precedent to back up her argument that there's a right to privacy in the Constitution. In the first argument, she basically just said, well, it's there somewhere. You'll have to find it if you look hard enough.
You're right, I misspoke. I was thinking of the former Solicitor General,
Erwin Griswold.
Erwin Griswold, and I should pay a little more attention to the text. This argument, did you notice it being different because there were 9 justices on the bench as opposed to 7 in the first round?
Well, I'm not quite sure because Justice Rehnquist and Justice Powell, who were the newest members of the court, didn't really ask any questions during the argument. It's sort of traditional that the first year or so justices, sit quietly and listen and wait. There have been some exceptions. Justice Scalia, of course, from his very first day on the court, has become a very insistent and even aggressive questioner.
Do you think you can draw any conclusions about how a justice is ultimately going to vote simply by listening to his or her performance during oral argument?
I really don't. There are some justices, Potter Stewart was an example, who take a devil's advocate role. They ask questions of both sides, very hard questions. Justice O'Connor does that now very often. She will ask questions of both sides that are equally probing. There are some justices whose positions are fairly easy to predict in advance, and many of these don't ask questions. Justice Brennan, for example, rarely asked questions during oral argument, and you pretty much knew where he was going to come out on a case.
Well, let's go back to finish up this oral argument from Roe versus Wade, and we commence with Assistant Attorney General Robert Flowers making his statement.
It is impossible for me to trace within my allocated time the development of the fetus from the date of conception to the date of its birth. But it is the position of the state of Texas that upon conception we have a human being, a person within the concept of the Constitution of the United States and that of Texas also.
Now, how should that question be decided? Is it a legal question, a constitutional question, a medical question, a philosophical question, a religious question, or what is it?
Your Honor, we feel that it could be best decided by a legislature in view of the fact that they can bring before it the medical testimony, the actual people who do the research. But we do have...
You think it's basically a medical question?
From a constitutional standpoint, no, sir. I think it's fairly squarely before this court. We don't envy the court for having to make this decision.
Flowers faced the same question Justice White posed to Weddington of balancing lives.
You're correct that the fetus is a person. Then I don't suppose you'd have the state would have great trouble permitting an abortion, wouldn't it?
Yes, sir.
In any circumstance.
It would, yes, sir.
To save the life of the mother or her health or anything else?
Well, there would be the balancing of the two lives. And I think that...
What would you choose? Would you choose to kill the innocent one or what?
Well, in our statute, the state did choose that way, Your Honor.
Well,
in the protection of the mother.
Flowers pressed ahead, but encountered sharp questions.
Gentlemen, we feel that the concept of a fetus being within the concept of a person, within the framework of the United States Constitution and the Texas Constitution, is an extremely fundamental thing.
Of course, if you're right about that, you can sit down. You've won your case.
Your Honor...
except insofar as maybe the Texas abortion law presently goes too far in allowing abortion.
Yes, sir. That's exactly right. We feel that this is the only question, really, that this court has to answer. We have
I think the case is over for you. You've lost your case then. If the fetus or the embryo was not a person, is that it?
Yes, sir. I would say so.
You mean the state has no interest of its own that it can assert
Oh, we have other interests, Your Honor. Preventing promiscuity, say.
Justice Marshall pushed Flowers harder.
I want you to give me a recognizable medical writing of any kind that says that at the time of conception, that the fetus is a person.
I do not believe that I could give that to you without researching through the briefs that have been filed in this case, Your Honor.
Flowers' arguments that the fetus was a person under the Constitution and that abortion was a legislative, not a judicial issue, provoked another round of questions.
If you're right that an unborn fetus is a person, then you can't leave it to the legislature to play fast and loose with that, in dealing with that person. In other words, if you're correct in your basic submission that an unborn fetus is a person, then abortion laws such as that which New York has is grossly unconstitutional, isn't it?
That's right. Yes.
Allowing the killing of people.
Yes.
Of persons.
Your Honor, the Massachusetts, I might point out...
You can't leave this up to the legislature. There's a constitutional problem, isn't it?
Well, if there would be any exceptions within this.
And the basic constitutional question initially is whether or not an unborn fetus is a person,
Yes.
isn't it?
And entitled to the constitutional
That's
protection.
critical to this case.
Yes,
isn't
sir, it is.
Flowers ended with these words.
I think that here is exactly what we're facing in this case, is the life of this unborn fetus paramount over the woman's right to determine whether or not she shall bear a child. This court has been diligent in protecting the rights of the minorities. And gentlemen, we say that this is a minority, a silent minority, the true silent minority. Who is speaking for these children? Where is the counsel for these unborn children whose life is being taken? Where is the safeguard of the right to trial by jury? Are we to place this power in the hands of a mother and a doctor? All of the constitutional rights. If this person has the person concept, what would keep a legislature under this grounds from deciding who else might or might not be a human being, or might not be a person?
In her rebuttal, Weddington stressed the significance of the decisions that faced both pregnant women and the 9 men on the Supreme Court bench.
No one is more keenly aware of the gravity of the issues or the moral implications of this case, but it is a case that must be decided on the Constitution. We do not disagree that there is a progression of fetal development. It is the conclusion to be drawn from that upon which we disagree. We are not here to advocate abortion. We do not ask this court to rule that abortion is good or desirable in any particular situation. We are here to advocate that the decision as to whether or not a particular woman will continue to carry or will terminate a pregnancy is a decision that should be made by that individual. That in fact she has a constitutional right to make that decision for herself, and that the state has shown no interest in interfering with that decision.
Chief Justice Berger.
Thank you, Mrs. Weddington. Thank you, Mr. Flowers. The case is submitted.
Professor Irons, that concludes your edited version of the audio tapes of Roe v. Wade from 1971 and 72. What happened next?
Well, several months later, after these arguments, the court issued its decision, January of 1973. And as we remember, it was a 7-2 decision in favor of the right to an abortion, striking down the Texas law. One of the interesting things about the court's opinion and the arguments we've just heard is that the issues really haven't changed in the last 20 years. The court has heard argument in, more than a dozen subsequent abortion cases, and really we're still arguing about a very basic and difficult question: when does life begin?
Why don't you give us a quick summary, if you would, as we run out of time, what the majority opinion concluded and who wrote it?
Well, Justice Harry Blackmun wrote the opinion. He had been the counsel for the Mayo Clinic for a number of years. He was interested in medicine, in fact, thought of becoming a doctor before he became a lawyer. He immersed himself, spent a whole summer in the Mayo Clinic library, went over all the medical literature, the history of abortion, and he wrote an opinion that really was an exhaustive investigation of the whole issue. And he basically concluded that there is no way the law can decide whether a fetus is a person, but that precedent had established that it did not have legal rights until after birth. And then based on that, he said there was a fundamental right to privacy broad enough to cover a woman's decision about childbirth. And he then went on to develop this trimester system, which has come under a great deal of attack as medical technology has changed. But basically what the court said was that in the first 3 months of pregnancy, the state cannot intervene at all in the decision about whether to have an abortion.
And the dissent? Excuse me, and the dissent?
Well, the two justices who dissented, Justice Rehnquist, who is now the Chief Justice, and Justice White, who is recently retired, both said that looking at the Constitution literally, there is no provision for abortion. And Justice Rehnquist said this is the kind of decision that should be made by elected lawmakers and not by judges. And I think that that is still the argument of many of those who say that the right to an abortion was created from the Constitution out of thin air.
Well, Professor Irons, the reason you're here is because you're responsible for bringing these oral arguments out to a broad public audience. I wonder, you mentioned at the beginning what your purpose was. What effect do you think that if these tapes get broad distribution, they will have, if any, on the court?
Well, I think they'll have two main impacts. One on students who are going to listen to these tapes in classrooms and really get into a discussion of these issues that they don't get just out of a textbook. We have, Stephanie Guitone and I have played these tapes and given them to high school teachers to play in their classes, and they come back and they say, the students were really excited, they were ecstatic, they really got into a big debate. One teacher played the case of Bakke versus the University of California case involving reverse discrimination. She said the students were really getting excited about this argument. I think the other impact it will have for the general public is to understand more about how the court works, how these decisions are made, how lawyers and justices debate these issues, and open up the court in a way that you can't do